Hello friends, welcome back to the series of lecture. This is the ninth lecture of this series of Indian Evidence Act. And in the previous lecture we had left over section 91 of the Indian Evidence Act. And let's continue with it. So it is saying when the terms of a contract or a grant or any other disposition of property have been reduced to the form of a document, no evidence no evidence shall be given in proof of the terms of such contract, grant or other disposition of property except the document itself or secondary evidence of its contents in case in which the secondary evidence is admissible under the provisions herein before contained. So secondary evidence is given in section 65 of Indian Evidence Act. Section 65 talks about where the secondary evidence can be given. So in the first part they are talking about any contract, grant or disposition. Then I told you it can be of any kind of contract, partnership, sale of goods, whatever. Grant normally will contain gift and disposition will contain, you say, any other disposition. Gift or contract के अलावा any other thing. I told you mortgage etc. That is also clarified. That will per se will not fall in this until unless the person is dead. Because without that there is not a transfer. So mortgage exchange will fall under this. And the simple requirement in first part is that either of these, if converted into writing, then the oral evidence will not be allowed in regarding the terms of the grant, disposition, contract, etc. And if there has to be any other evidences to be given that there was a contract, then that would be allowed to do so. Or anything else written into the document which is not at all of the contract, not at all at the term of the contract, that will be allowed. Oral evidence. There also, broadly, section 59 will be applied. Because section 59 generally says if something is recorded in writing, then document has to be proved. Or if electronic way, then that electronic thing is to be proved. So, in any way, if something is recorded, then that has to be proved. But at least 91 will not apply. 91 will apply only with the terms of that contract. So write down on the first part. Section 91 relates to exclusivity of document. Relates to exclusivity of documents. That is, if the condition of section 91 is fulfilled, then the documentary evidence alone will be allowed to be proved and not the oral evidence. If the condition of section 91 are fulfilled, then the documentary evidence alone will be allowed to be proved and not the oral evidence. In the case of a contract, grant or any other disposition of property, it is clearly stated that if the said contract, grant or disposition was reduced to writing, then the terms of the said contract, grant, etc. can be proved only by the documentary evidence, and the oral evidence shall be excluded. Then in the document also only the original document can be proved. Thus, a secondary evidence will be allowed only if the conditions of section 65 are fulfilled. The next para. What is prohibited is the proof of the terms of the said contract, grant or disposition by oral evidence. And therefore, if oral evidence is sought to be given regarding any other thing, fact, for example, the fact that the contract was entered into the transaction of contract, bracket, means the fact that the contract was entered into means जो contract का transaction हुआ or any other thing written in the document which is not a term of the said contract can be proved by the oral evidence. So this is the first part of 91. Exclusivity of contract means what? Exclusivity of documentary evidence. What it means? If they have got documentary as well as the oral evidence, suppose there is a contract between A and D. There was contract between A and D and it was documented. The terms are written here. The terms are written here. And at the same time, the W and W1 are the witnesses also. Eyewitness of the contract. Now suppose tomorrow there is a dispute between A and D and A want to prove the contract. Then he seeks to prove the contract by documentary evidence. Then that will be allowed. But if he seeks to prove the contract by the witnesses of W and W1 as the witnesses of the contract, then this will not be allowed for proving the terms of that contract, what is written in it. But suppose he simply wants to prove by the witnesses of testimony of W and W1 that there was a contract, that A and D was entered into the contract on particular date, not the terms. They are produced for the proving of only of the fact that contract was entered on that date. Then the W1 and W will come and give the evidence that yes, in front of us the contract was entered. But the moment they get into proving the terms of the contract, then it will be prohibited. अब एक बार आप section 144 निकालिए. We would see half of the part of this for now. And you always have to read this with 9192. Any witness may be asked while under examination whether any contract, grant or disposition of the property. Any witness may be asked while under examination whether any contract, grant or other disposition of property as to which he is giving evidence was not contained in a document. अब मान लो A और B के बीच में dispute हो गया breach of contract का. अब मान लो in the pleadings he has not revealed that it is a documented thing. Pleadings में इन्हें नहीं बताया कि the contract is documented. अब A produce a witness to prove the contract. अब while the witness is examine in chief, B will cross-examine the witness. While when it is cross-examined by the opposite party B, then the B will ask a question of the contract, grant or disposition of which the witness is giving the evidence. Was that converted into writing? And the moment the witness says yes, and there will the section 91 will apply. जैसे ही विटनेस बोलता है कि रिटन में हुआ था तो उसी समय 91 अप्लाई हो जाएगा. एंड द अपोजिट पार्टी ऑब्जेक्ट, opposite party will object and the opposite party will require the document to be proved and the witness's testimony will be excluded. So opposite party may be asked, पूछ सकती है कि document to be presented and the oral testimony of the witness be excluded. So read again. Any witness may be asked while under examination whether any contract, grant or other disposition of property as to which he is giving evidence was not contained in a document, and if he says that it was, or if he is about to make any statement as to the contents of any document which in the opinion of the court ought to be produced, the adverse party may object to such evidence being given until such document is produced or until facts have been proved which entitle the party who called the witness to give secondary evidence of it. So you see that there is a witness being examined in the case in a civil suit in reference to a contract grant or disposition, and witness is giving oral evidence of the terms of the said contract grant or disposition. The terms. Now the opposite party cross-examines him and puts a question whether the said contract etc. was reduced to document. And the moment witness says yes or otherwise the court believes that the document has to be produced, then in that case the opposite party will raise an objection and the oral testimony will not be allowed by the virtue of the section 91. Then the oral testimony has been rejected and the document has to be proved. अब इसका लास्ट पार्ट है जो ये अभी समझ में नहीं आएगा, आपको अभी ये पूरा क्लियर नहीं होगा और ना ही अभी इस सेक्शन को हम खत्म कर रहे हैं, बिकॉज दिस सेक्शन इज रिलेटेड टू सेकेंडरी एविडेंस, और जब तक उसको हम नहीं पढ़ेंगे ये लेटर पार्ट आपको पूरा समझ में नहीं आएगा. बट एक बार पढ़ लेते हैं इसको. Any witness may be asked while under examination whether any contract grant or other disposition of property as to which he is giving evidence was not contained in a document. And if he says that it was, or if he is about to make any statement as to the contents of any document. अब पहला पार्ट है yes if he says that it was documented, or if he is about to make a statement as to the contents of any document. अब ये सेकंड पार्ट है, इससे अभी हमको कोई मतलब नहीं है. कोर्ट में हम किसी डॉक्यूमेंट के कंटेंट का स्टेटमेंट करना चाहते हैं. आई वॉन्ट टू मेक द स्टेटमेंट रिगार्डिंग द कंटेंट्स ऑफ द डॉक्यूमेंट. उसके लिए आप 63 क्लाउज 5 पढ़ोगे. देयर इट इज ए सेकेंडरी एविडेंस. अब उसमें हम अभी डिटेल में नहीं जा रहे, बट उसमें क्या है, सपोज दिस इज ए डॉक्यूमेंट एंड आई हैव पर्सनली रेड दैट डॉक्यूमेंट. अब दिस original document cannot be produced as evidence, so any person who have read the contents, he may stand in the court and declare that I have read the contents of the document, and that has to be proved whether he has read or not. वो तो उसको प्रूव करना पड़ेगा, that is different thing, but he may state the contents of the document. That is called secondary evidence 63 clause 5 में. And it is obviously when you are giving secondary evidence, then secondary evidence will be allowed or not. For that, section 65 has to be proved. So that is what they are saying in the second part, which I will explain it later on again. And if he says that it was, or if he is about to make any statement as to the contents of any document, which in the opinion of the court ought to be produced, the adverse party may object to such evidence being given until such document is produced or until facts have been proved which entitle the party who called the witness to give secondary evidence of it. So मतलब or until the facts have been proved, until section 65 is fulfilled. So latter part we are not concerned with, we are talking about the first part. And the first part clearly says that if you are giving the terms of some contract, grant, disposition, etc. by oral way, then the opposite party may ask you that whether it was documented, and if it was, then he will raise the objection in section 91, and in that case the oral testimony will not be allowed. Only the documentary evidence has to be produced. So this 144 first part has reference to section 91, and the second part is having reference to section 63 clause 5 and section 65. अब मान लीजिए ऐसी सिचुएशन आ जाती है क्रॉस एग्जामिनेशन में, जो अपोजिट पार्टी है उसने स्टॉप नहीं किया for producing the document and examination of it. Opposite party ने objection नहीं लिया, then the court can, because the court has the power to stop. Court can stop because the bar is per se. The bar is not on the party. It is not necessary that bar is only raised by the party. The bar is per se. अब मान लीजिए कोर्ट ने भी स्टॉप नहीं किया, उसका ओरल एविडेंस ले लिया है, and tomorrow in appeal the party can again raise the objection, but the appellate court may again ask the party who is raising the objection, who had gone into the appeal, that why were you sleeping upon your rights? And in appeal the court will not normally allow that objection, but in the same trial you can raise the objection. क्योंकि 91 में लिखा है when the terms of contract etc etc, then no evidence shall be given in proof. No evidence shall be given in proof. No evidence shall be given means what? It is a mandatory provision and it is binding, and court shall not allow such evidence. But suppose by chance such evidence is allowed, because court is not a machine, court is also a human being. Suppose by chance such evidence is allowed, no party raised the objection, and therefore the court allowed, and the suit was decided, and now the party in the appeal goes into the appeal, and now they raise the objection that the contract was documented and the oral evidence was allowed, and therefore this oral evidence will be excluded and the decree shall be set aside. Then there is two problems. One problem is that the trial court had allowed or had admitted an inadmissible evidence, because oral evidence of the contents of document is inadmissible. Contents of the document आप उसके document से prove करोगे, तो उस situation में oral evidence is inadmissible and it was allowed, and for that section 167 applies, which says that if that evidence was not allowed, for example if that evidence was not allowed, then would the judgment would be different. अगर उस एविडेंस को अलाउ नहीं किया जाए तो क्या जजमेंट पे कोई फर्क पड़ेगा, डिफरेंट होगा. So there the section 167 will be examined. So again that has to be discussed later on. Then the second, the court will always have in mind that this person has to be raising the objection and does not raise the objection, he was sleeping upon his rights, and now at the appellate stage he raises the objection, then the court may disallow the objection at that stage or in the appeal. लेकिन उस पे पॉइंट्स दिए गए हैं कि कोर्ट को लगता है कि अगर किसी बोनाफाइड रीजन की वजह से उसने ऑब्जेक्शन रेज नहीं किया था, अपोजिट पार्टी ने इसके साथ कोई फ्रॉड कर दिया जिसकी वजह से ये ऑब्जेक्शन रेज नहीं कर पाया, और उस इनएडमिसिबल डॉक्यूमेंट को उस इनएडमिसिबल एविडेंस को एडमिट करने की वजह से डिफीट ऑफ द एंड्स ऑफ जस्टिस हो गया है, देन एट द अपलेट स्टेज the court still allows the objection. It will set aside the decree and require the document to be produced. So now let's see the exceptions and explanation. Then we will move into the second part of section 91. Exception 1. When a public officer is required by law to be appointed in writing, and when it is shown that any particular person has acted as such officer, the writing by which he is appointed need not be proved. So basically they are creating two exceptions here. One exception is, suppose there is district magistrate in a district is required by law to be appointed in writing, and if he was appointed in the office for suppose 2-3 years, and the later on if a question arises whether he was validly appointed or not, so there they are giving an exception that in that case for the appointment purpose For the appointment purpose, you need not to prove the document which is required to be in writing. The fact that he had hold that office for so many days, months or years, that will be sufficient enough to prove that he was appointed. So that is one exception when a public officer is required by law to be appointed in writing, and when it is shown that any particular person has acted as such officer, the writing by which he is appointed need not to be proved. So then what shall be proved? What shall be proved? That the fact that he hold that office for all that period, that is sufficient enough to prove for the fact that he has been appointed. अब इस केस में ऑब्वियसली अगर आप फ्रॉड शो कर दो कि दैट ही हैज fraudulently hold that office, then in that case the document has to be shown. But in the general rule is that कि डॉक्यूमेंट शो करने की आपको जरूरत नहीं पड़ेगी. You just prove the fact that he has hold the office for that number of days. Exception 2. Wills admitted to probate in India may be proved by the probate. अब suppose A makes a will to B. A makes a will for B. A makes a will for B, and it is the original will in his handwriting, in A's handwriting. अब suppose tomorrow there is a dispute after the death of A. A has died, and since by the will B is having the property as per will, that whole of the property lies to B, and there is dispute after death of A. There are other persons C, D, etc. And these all people C, D, etc. saying that the property holded by the B is illegally holded. Now, in this situation, B has to prove the will. He has to prove that he became the owner of the property through the will, through the testamentary succession. Now, we will have to produce the documentary evidence only. अब विल का मैंने बताया था कि जब तक टेस्टेटर जिंदा है, इट विल नॉट फॉल अंडर 91. जैसे ही टेस्टेटर मर गया, इट विल फॉल अंडर 91. Then the prohibition of 91 will apply. So obviously oral evidence will not be allowed. Only this document will be allowed. So here they are making a clarification that even if the original will, which is actually written by A, is not proved, the probate of the will, if that is proved, that will be sufficient. If the probate of the will is proved. तो आप अगर ओरिजिनल विल प्रूव ना करके विल का अगर प्रोबेट प्रूव कर देते हो, then that also be sufficient. We don't need to prove this original document, this will. But yes, प्रूव तो आपको डॉक्यूमेंट ही करना पड़ेगा. ओरिजिनल बस डिफरेंस ये है, ओरिजिनल विल प्रूफ ना करने की जगह आपको ओरिजिनल प्रोबेट प्रूफ करना पड़ेगा. अब नाउ द क्वेश्चन अरोज, व्हाट डू यू मीन बाय प्रोबेट? Whenever there is a will in your favor, then you will go to the probate court for obtaining the probate. In the probate court, जब आप probate court में जाओगे, then the probate court will examine the genuineness of the will, and for that purpose it will serve the notices to the all persons concerned. Court will serve notices to all the other person concerned who may be relatives of the legator, and for that public notice also be given soon. And after examining the objection, public notice जो होगा वो न्यूज़पेपर एक्सेट्रा में दिया जाएगा. And after that objection came, whoever wants to raise the objection, they will raise the objections before that court. And after taking all the objections and hearing everyone, the court will examine the genuineness of the will, and if the court finds that the will is genuine, then it will issue a certificate of the genuineness, and that certificate of genuineness will be called the probate, and that certificate of genuineness is in typed form and stamped by the court, that is called probate. तो बाद में आपका जो ओरिजिनल विल है वो अगर आप प्रूफ ना कर पाओ तो उससे कोई फर्क नहीं पड़ेगा, आप उसके बदले में जो कोर्ट ने सर्टिफिकेट इशू किया था उसको आप प्रूफ कर दो, तब भी आपका विल प्रूफ हो जाएगा। लेकिन आपका ओरल एविडेंस अलाउड नहीं होगा। यू हैव टू प्रूव द टर्म्स ऑफ द विल बाय producing document itself. But if not having the original will, then prove the probate. So wills admitted to probate in India may be proved by probate. Wills admitted to probate means what? A will for which a probate has been issued by the probate court. अब probate court जरूरी नहीं है कि probate court कोई जुडिशियल ऑफिसर हो, एग्जीक्यूटिव कोर्ट भी probate ऑफिसर होते हैं, सॉरी एग्जीक्यूटिव ऑफिसर भी प्रोबेट कोर्ट होते हैं। तो एग्जीक्यूटिव ऑफिसर भी नोटिस देंगे, रिलेटिव्स को सबको नोटिस जाएगा, न्यूज़पेपर में देंगे। देन इफ नो वन ऑब्जेक्ट्स और इफ एनी वन ऑब्जेक्ट्स आफ्टर हियरिंग देम, देन आफ्टर दैट द सर्टिफिकेशन विल बी देयर दैट विल इज प्रॉपर, और उसमें डीएम का सिग्नेचर वगैरह स्टैम्प वगैरह होगा, एचडीएम का सिग्नेचर और स्टैम्प रहेगा। एंड वंस दैट इज डन देन द प्रोबेट इज फाइनल। और सेक्शन 41 एविडेंस का इट टॉक्स अबाउट द जजमेंट इन रेम, और प्रोबेट कोर्ट का जो जजमेंट है दैट इज जजमेंट इन रेम, दैट इज अगेन द होल वर्ल्ड एट लार्ज। नाउ लेट्स सी एक्सप्लेनेशंस। एक्सप्लेनेशन 1, दिस सेक्शन अप्लाइज इक्वली टू केसेस इन विच द कॉन्ट्रैक्ट्स, ग्रांट्स और अदर डिस्पोजिशंस ऑफ प्रॉपर्टी referred to are contained in one document and to cases in which they are contained in more documents than one. What does this mean? Suppose there is a contract between A and B. So you have to prove this document, produce this document, oral document for the terms is not allowed. But this talks about this situation. Suppose there is on a particular date, A writes a letter to B. Then on a particular date, B writes a letter to A. And then there is correspondence between these two. And finally, here the offer is accepted. अब इस सिचुएशन में ये जितने लेटर्स हैं ये सारे मिलकर, जब तक फाइनल एक्सेप्टेंस हुआ है, सारे मिलकर एक कॉन्ट्रैक्ट बना रहे हैं। बिकॉज कॉन्ट्रैक्ट में प्रपोजल आएगा, ऑफर, एक्सेप्टेंस, ये सारी चीज आएंगी। व्हेन यू रीड द कॉन्ट्रैक्ट एक्ट, आई वुड टीच यू इन डिटेल्स ऑफर क्या था, एक्सेप्टेंस हुआ कि नहीं हुआ, कहीं अपने आप ही एक्सेप्टेंस कर लिया हो तो ऑफर्स को देखा जाएगा पूरा, फिर एक्सेप्टेंस देखा जाएगा, या फिर एक प्रपोजल है, काउंटर प्रपोजल हो सकता है, ऑल दीज थिंग्स। सो इस तरीके के कॉन्ट्रैक्ट में ये सारे जितने भी डॉक्यूमेंट्स हैं ये आपको प्रोड्यूस करने पड़ेंगे। सो ए सिंगल कॉन्ट्रैक्ट विच इज क्रिएटेड थ्रू सीरीज ऑफ डॉक्यूमेंट्स थ्रू करस्पॉन्डेंस, तो वो सारे आपको प्रोड्यूस करने पड़ेंगे। अब इसके लिए आप इलस्ट्रेशन नंबर 1 देख लीजिए। इफ ए कॉन्ट्रैक्ट बी कंटेन्ड इन सेवरल लेटर्स, all the letters in which it is contained must be proved. So this is the same thing, it is related to explanation number 1, that if there is series of letters or documents, in that situation, in order to prove the said contract, oral evidence will not be allowed, and if documentary evidence also, you have to prove all those documents. Explanation 2, where there are more originals than one original only need to be proved. अब सपोज देयर इज ओनली वन कॉन्ट्रैक्ट, बट व्हेन यू रोट द कॉन्ट्रैक्ट एट एट दैट टाइम यू रोट टू ओरिजिनल्स। कई बार होता है कि आपने दो डॉक्यूमेंट्स बनाए और दोनों पर दोनों पार्टीज ने साइन किया। कॉन्ट्रैक्ट एक ही है मान लो, और दो डॉक्यूमेंट्स बनाए आपने, इस पे भी ए और बी ने साइन किया, इस पे भी ए बी ने साइन किया, तो फिर ये दोनों कॉन्ट्रैक्ट ओरिजिनल हो जाएंगे। टर्म्स एंड कंडीशन सारी कॉन्ट्रैक्ट के वो सेम है। इस सिचुएशन में एक कॉपी ओरिजिनल ए रख लेता है, एक बी रख लेता है। नॉर्मली ऐसा होता नहीं है, कॉन्ट्रैक्ट एक ही बनता है, एक पार्टी दोनों पार्टियों ने साइन कर दिया, उसकी कॉपी दोनों पार्टियों को पकड़ा दी जाती है। लेट अस टेक एग्जांपल, ए ने एक कोई हाउस खरीदा और वो दैट हाउस इज अंडर टेनेंसी, उसमें कोई टेनेंट रहता है, टेनेंसी ऑफ समवन। और बी ने वो हाउस खरीदा, बी से वो हाउस जो ए ने खरीदा, तब बी ने टेनेंट को इन्फॉर्म कर दिया दैट आई एम सेलिंग माई हाउस, दैट नाउ ऑनवर्ड्स दिस हाउस वुड बी अंडर द ओनरशिप ऑफ ए। अब इस सिचुएशन में जब हाउस की ओनरशिप ट्रांसफर हो रही है तो अटॉर्नमेंट से भी काम चल जाएगा, बी अटॉर्न कर दे ए को फॉर द टेनेंसी। बट मान लो ए चाहता है कि फ्रेश टेनेंसी टू बी साइंड बाय टेनेंट टी, सो फ्रेश रेंट एग्रीमेंट शुड बी साइंड बिटवीन द ए एंड टी। अब ए ने टू कॉपीज बनाई, मान लो स्टैम्प पेपर भी दो ले लिए 100 रुपए के अलग, और बोथ द कॉपीज में ए ने साइन कर दिया और दोनों कॉपीज टी को दे दिया, टी ने दोनों कॉपीज पर साइन कर दी। अगर मान लो स्टैम्प पेपर एक ही होता, उसकी कॉपी निकाल ली, खाली फोटो कॉपी की होती और बाकी के पीछे के ओरिजिनल दो जो पेपर्स हैं टर्म्स ऑफ टेनेंसी that would be different in the single print from the same computer at the same time, then also that would be not the two originals, that would be copies only. But in this situation we are talking about the stamp papers are also different. अब एक कॉपी ए पर है, एक कॉपी टी पर है। अब ये दोनों ओरिजिनल है, सेम प्रिंटिंग कमांड पे दोनों प्रिंट आउट निकाले गए थे और सेम प्रिंटिंग कमांड पे दोनों का सिग्नेचर हुआ है। सो कई बार होता है कि आप दो ओरिजिनल बनाते हो तो और आपको डॉक्यूमेंट प्रूव करना है किसी केस में, क्या दोनों ओरिजिनल को आपको प्रोड्यूस करना पड़ेगा या फिर एक से काम चल जाएगा? दैट इज गिवन इन दिस एक्सप्लेनेशन, इन एक्सप्लेनेशन नंबर 2, कि आपका एक से काम चल जाएगा। वेयर देयर आर मोर ओरिजिनल्स देन वन ओरिजिनल ओनली नीड बी प्रूव्ड। द स्टेटमेंट इन एनी डॉक्यूमेंट whatever of effect other than the facts referred to in this section shall not preclude the admission of oral evidence as to the same fact. The statement in any document whatever of effect other than the facts referred to in this section. What facts are referred to in this section? Terms of that contract, grant or disposition. Now in the previous lecture I told you, suppose there is a document, there was a document between A and B, and in this document they have written all the terms of the contract, and somewhere in this document only they have written something which is not related to the present contract or transaction. For example, in the previous lecture I had told you that they have written a term in this contract of a previous transaction of 2 lakhs which is not paid. अब ये जो स्टेटमेंट है, ये टर्म है, दैट इज नॉट रिलेटेड टू द प्रेजेंट कॉन्ट्रैक्ट, दिस ट्रांजैक्शन इज नॉट रिलेटेड टू दिस ट्रांजैक्शन, दिस टर्म इज ऑफ सम अर्लियर ट्रांजैक्शन। अब इफ यू वांट टू सीक सम ओरल एविडेंस ऑफ दिस टर्म और दिस ट्रांजैक्शन, क्या इस स्टेटमेंट का ओरल एविडेंस 91 प्रोहिबिट करेगा? Will the 91 prohibit the oral statement of this term, this statement? The oral evidence of this statement is not prohibited because it is not the term of present contract. अब 91 तो नहीं करेगा इसको, but 59 says that if the term is documented Since it is documented, the oral evidence is not allowed. But as far as 91 is concerned, 91 will not prohibit it, because 91 prohibits only if the statement was term of that contract, main contract. The statement in any document, whatever, of a fact other than the facts referred to in this section shall not preclude the admission of oral evidence as to the same fact. See illustration D for this. A contract A contracts in writing with B for the delivery of indigo upon certain terms. The contract mentions the fact that B had paid A the price of other indigo contracted for verbally on other occasion. In this illustration, the present contract is the contract for supply of the indigo, but in the same document, one statement is written that the amount for the earlier transaction also be paid. अब ये स्टेटमेंट है कि पहले वाले ट्रांजैक्शन का अमाउंट भी यू विल पे हियर. Is that related to this present contract? No. इसमें प्रेजेंट कॉन्ट्रैक्ट के टर्म्स लिख दिए और साथ में कहीं एंडोर्समेंट कर दिया कि जो पिछले कॉन्ट्रैक्ट का पेमेंट था वो भी हम पे कर रहे हैं. ये लिख दिया कहीं पे एंडोर्समेंट में. सो दैट स्टेटमेंट इज नॉट ऑफ द प्रेजेंट कॉन्ट्रैक्ट. दैट स्टेटमेंट इज नॉट एट ऑल of the present contract. A contracts in writing with B for the delivery of indigo upon certain terms. The contract mentions the fact that B had paid A the price of the other indigo. B had paid A the price of other indigo contracted for verbally on another occasion. Oral evidence is offered that no payment was made for other indigo. The evidence is admissible. And 59 is a broad directive provision, and it is not as mandatory and as rigid. So if you want to permit a oral evidence, then it may be permitted. लेकिन अगर ये statement term of the contract होता, in 91 it will not be allowed to be proved orally if it was a term of contract. Now let's see illustration E. A gives B receipt for money paid by B. Oral evidence is offered of the payment. The evidence is admissible. You see, there is some amount due upon A. There was some amount due upon A. There is an amount due upon B. A के कुछ पैसे B पर हैं. And B makes the payment to A. And A gives receipt for that. A ने उसका रिसिप्ट B को दे दिया that I have obtained so and so amount on so and so date from the B. अब B later on wants to give oral evidence. किसी विटनेस को बुलाना चाहता है कि देखिए मैंने इसके सामने पैसे वापस कर दिए थे. Then in this situation will it be permitted? अब ये मैं आपको बता चुका हूँ जो ट्रांजैक्शन जो है whether there was a contract in written or not, तो कॉन्ट्रैक्ट का एविडेंस हम दे सकते हैं, बट अगर कॉन्ट्रैक्ट रिटन में है तो उसके टर्म्स का एविडेंस ओरल हम नहीं दे सकते. कॉन्ट्रैक्ट ओरली हुआ है देन दैट इज अ डिफरेंट थिंग टू प्रूव द टर्म्स ऑफ दैट. अब इस केस में ये क्या प्रूव करना चाह रहा है कि मैंने पेमेंट दिया था. ही इज नॉट सीकिंग टू प्रूव एनी ऑफ द टर्म्स ऑफ द रिसिप्ट. हो सकता है रिसिप्ट कुछ टर्म्स लिखे हों. ही इज नॉट प्रूविंग द terms of the receipt. He is proving only that that I have given the money. So that transaction can always be proved. What cannot be proved is the terms of the transaction. But here what they want to prove is that there was a payment made by B. अब इसी तरीके से B देख लो. If a contract is contained in a bill of exchange, the bill of exchange must be proved. So oral evidence will not be allowed. Then if a bill of exchange is drawn in a set of three original bill of exchange, three sets of, अब उनमें से कितने प्रूव करोगे, सारे या वन ओनली नीड टू बी प्रूव्ड. तो ये आपका एक्सप्लेनेशन नंबर 2 से रिलेटेड है. नाउ नेक्स्ट यू हैव टू सी द सेकंड पार्ट ऑफ सेक्शन 91. Second part of the 91. For the second part, read from here. In all cases in which any matter is required by law to be reduced to the form of a document, no evidence shall be given in proof of the terms of such matter except the document itself or the secondary evidence, where the secondary evidence is admissible. So basically the second part relates to what? It relates to the matters required by law to be reduced to writing. If the law requires the particular matter to be reduced into the writing, तो उस पर आप oral evidence तो कर ही नहीं सकते, क्योंकि लॉ की रिक्वायरमेंट ही है कि वो रिड्यूस्ड होना चाहिए राइटिंग में. और अगर बाई चांस आपने रिड्यूस्ड नहीं किया राइटिंग में, it was only oral, then also the oral evidence will not be allowed. क्योंकि यहाँ पर पार्ट 1 की तरह ये नहीं लिख रहे कि कॉन्ट्रैक्ट रिड्यूस टू द राइटिंग. यहाँ पर सीधा कह रहे हैं द लॉ रिक्वायर्ड टू रिड्यूस इनटू राइटिंग, and irrespective of the error that you reduced it into the writing or not, only the document can be proved and the oral evidence cannot be given. So that is the language is little bit harsh, क्योंकि यहाँ पर ये कहीं नहीं लिख रहे हैं if it was reduced into writing. They are not saying that the law required it to be in the form of document, and if it is documented or reduced into writing, then oral evidence will not be allowed. They are simply saying that if the law requires it into reduced into writing, no evidence will be allowed except the document itself, documentary evidence. Means if the law required the matter to be reduced into writing or documentation form, you have to reduce it into the writing in the documented form. Then the document evidence will be allowed. So if the law requires it to be written or documented form, and if you not reduced it into the writing and documentation, then also the documentary evidence will be required. और फिर आपने जब reduced ही नहीं किया documentation में, तो documentary evidence आपके पास होगा नहीं, और oral evidence इधर allowed होगा नहीं. जबकि पहले पार्ट में क्या था, अगर राइटिंग में रिड्यूस किया है, डॉक्यूमेंटेशन में किया है कोई कॉन्ट्रैक्ट ग्रांट और डिस्पोजिशन, तब आपका सेक्शन 91 लगेगा. जबकि सेकंड पार्ट में वैसा कुछ भी नहीं है. अगर सेकंड पार्ट में यह है कि अगर लॉ रिक्वायर करता है आपको कि राइटिंग में रिड्यूस करना चाहिए, और आपने राइटिंग में रिड्यूस किया है या फिर नहीं किया है, सेक्शन 91 will apply. Therefore, the oral evidence will not be allowed to be proved. So this is the main issue. So write down, in the second part of 91, section 91, those matters will fall which are required by the law to be reduced to writing, and which have not been reduced to writing or have been reduced to writing in either case. In either case, the oral testimony of the matter will not be allowed. Thus, even if it was not reduced to writing, oral evidence will not be allowed. देखिए सिंपल सी बात है. फर्स्ट पार्ट में कॉन्ट्रैक्ट ग्रांट और डिस्पोजिशन, वो तभी सेक्शन 91 में फॉल करेगा अगर आपने उसको राइटिंग में रिड्यूस किया है। जबकि सेकंड पार्ट में कोई भी मैटर अगर लॉ द्वारा रिक्वायर्ड है कि उसको राइटिंग में रिड्यूस करना है, तभी सेकंड पार्ट में फॉल करेगा। और उस सिचुएशन में जब लॉ द्वारा रिक्वायरमेंट है कि राइटिंग में कन्वर्ट करना चाहिए, तो उसको आपने अगर राइटिंग में कन्वर्ट किया है तब भी और राइटिंग में कन्वर्ट किया नहीं किया है तब भी सेक्शन 91 लगेगा एंड द ओरल एविडेंस विल नॉट बी अलाउड। और जबकि फर्स्ट पार्ट में डॉक्यूमेंटेशन नहीं किया था तो ओरल एविडेंस दे सकते हो, और जबकि सेकंड पार्ट में अगर आपने डॉक्यूमेंटेशन नहीं किया है तब भी आप ओरल एविडेंस नहीं दे सकते हो। Why? Because law requires it to be documented. So write it down. In the first part, 91 apply only if contract, grant, etc. was documented. And if not documented, then oral evidence would be allowed. Documented, then the oral evidence could be allowed. If not documented, then oral evidence could be allowed. However, if the matter falls in the second part, then unlike the first part, if the transaction was not documented, then also oral evidence will not be allowed. और इसमें हम एग्जाम्पल्स देख चुके हैं। जो एक एग्जाम्पल दिया था, द केस ऑफ सेक्शन 164 CRPC, recording of the confessions, statement of confessions. In section 164, the magistrate first class is required by law to record the confession, and if he does not record the confession, then oral evidence will not be allowed by virtue of the second part of the section 91. If it is recorded, it was recorded, then also, or if it was not recorded, then also oral evidence is not allowed. एडॉप्शन के अथॉरिटी के एग्जाम्पल में ये बताया था कि it is in the same situation if it is recorded, then also, if it is not recorded, then also oral evidence is not allowed. Why? Because it is required by law to be get documented or registered. उसी तरीके से प्रीवियस लेक्चर में हमने बहुत सारे एग्जांपल्स देखे थे. No need to repeat here. Now let's discuss next issue. Here it is said the contract, grant or disposition. Contract, grant or disposition has to be reduced into writing. If it is oral, contract, grant, disposition, if it is oral, तो oral evidence दे सकते हैं. But if it is documented, then only documentary evidence is allowed. तो इतना तो हम जान ही चुके हैं. But you must appreciate there are certain contract, grant or disposition which as per the Registration Act required to be get registered. Now you tell me, suppose if the contract, grant or disposition for any immovable property of ₹100 or more की है, तो उसको रजिस्ट्रेशन एक्ट में सेक्शन 17 में रजिस्टर्ड करवाना जरूरी है एज पर सेक्शन 17 ऑफ रजिस्ट्रेशन एक्ट. अब वैसा कोई कॉन्ट्रैक्ट हो जिसका रजिस्ट्रेशन जरूरी है, इफ देयर इज सच कॉन्ट्रैक्ट एज पर रजिस्ट्रेशन एक्ट whose registration is necessary, essential, then in that case the oral agreement is not allowed. Then tell me, in that case can the oral evidence can be given? So that kind of contract, grant or disposition will not fall in the first part, that would shift into the second part. So यही इशू था कि हर कॉन्ट्रैक्ट, ग्रांट और डिस्पोजिशन पे फर्स्ट पार्ट लगेगा, ये जरूरी नहीं है. Those contract, grant or dispositions for which registration is compulsory, they will not fall in the first part of the 91. They will shift into the second part because they are essential to be recorded. They are essential to be documented. Because registration is to be compulsory का मतलब क्या है? Means they are essential to be recorded. And therefore, in those kinds of contract, grant or disposition, part 1 does not apply. Part 2 applies. And therefore, if they are not recorded, then also the oral evidence will not be allowed. लेकिन अगर रजिस्ट्रेशन कंपलसरी नहीं था तो फर्स्ट पार्ट में लाई हो जाएगा, और जब रजिस्ट्रेशन कंपलसरी नहीं है तो डॉक्यूमेंटेशन की ज़रूरत नहीं है, और वहाँ पे अगर ओरल है तो ओरल एविडेंस अलाउड हो जाएगा, और अगर डॉक्यूमेंट है तो डॉक्यूमेंट की ज़रूरत पड़ेगी। अब यहाँ पर मैं आपको कुछ पॉइंट्स रजिस्ट्रेशन एक्ट के बताना चाह रहा हूँ। अब ये जो सेक्शन 17 है रजिस्ट्रेशन एक्ट का, आई एम नॉट रीडिंग ऑल ऑफ इट, रीडिंग सम पोर्शन ऑफ इट। The following documents shall be registered if the property to which they relate is situated in a district in which, and if they have been executed on or after the date on which so and so and so or this act comes into force। तो इस पोर्शन से हमें मतलब नहीं है, हमें मतलब है आगे इंस्ट्रूमेंट्स ऑफ गिफ्ट ऑफ इमूवेबल प्रॉपर्टी। कभी भी आप इमूवेबल प्रॉपर्टी का गिफ्ट करोगे तो उसको रजिस्टर करना जरूरी है। तो कॉन्ट्रैक्ट ग्रांट में गिफ्ट आएगा, दैट ऑलवेज हैज टू बी रजिस्टर्ड ग्रांट, अगर वो इमूवेबल प्रॉपर्टी है। अब कोई मूवेबल प्रॉपर्टी है, आपको अपना मोबाइल गिफ्ट करना है तो जरूरत नहीं है। अगर मकान और ज़मीन करनी है देन यस। तो अगर मोबाइल का गिफ्ट किया तो फर्स्ट पार्ट, और मकान का गिफ्ट किया, ज़मीन का गिफ्ट किया तो सेकंड पार्ट। देन अदर नॉन टेस्टामेंट्री इंस्ट्रूमेंट विच परपोर्ट और operate to create, declare, assign, limit or extinguish, whether in present or in future, any right, title or interest, whether vested or contingent of the value of 100 rupees and upwards, to or in immovable property। वसीयत के अलावा, विल के अलावा कोई भी ऐसा ट्रांजैक्शन in which you are creating a right upon some other person, upon some immovable property of a value 100 rupees or more. So that can be a contract, that can be a disposition. So any such transaction by which you are creating a right upon a movable property of 100 rupees or more, that always has to be immovable property, that always has to be registered. So all those contracts, grants or disposition which are of the value of 100 rupees or more related to immovable property, they all need to be get registered. And since they all need to be get registered, they will all fall into the second part। और गिफ्ट के केस में, ग्रांट के केस में इनफैक्ट 100 रुपीज एक्सेट्रा देखने की जरूरत नहीं है। वॉट एवर विल बी द वैल्यू, इफ इट इज immovable property, it will fall into the second part। And therefore what I want to highlight here is that all kinds of contract, grant and dispositions will not fall in the first part। There are several contract and grants and dispositions which do falls in the second part of the section 91 because they are compulsory to be registered। So write it down. There are certain contract, grants or disposition of property which are required by the Registration Act essentially to be registered, and therefore such matters would fall under section 91 second part। Accordingly, in such cases, if the transaction is not documented, then also the oral evidence will not be allowed। मतलब कॉन्ट्रैक्ट, ग्रांट और डिस्पोजिशन के लिए दो चीज हो गई, रिक्वायर्ड टू बी गेट रजिस्टर्ड और दूसरा यहाँ पे नॉट रिक्वायर्ड टू बी गेट रजिस्टर्ड। अब सेक्शन 91 का फर्स्ट अप्लाइज व्हेन इट इज डॉक्यूमेंटेड। अगर ये डॉक्यूमेंटेड नहीं है तो सेक्शन 91 का फर्स्ट पार्ट नहीं लगेगा, सेक्शन 91 ही नहीं लगेगा। सो अगर ओरल है, ओरल कॉन्ट्रैक्ट हुआ था ग्रांट या डिस्पोजिशन, तो ओरल एविडेंस अलाउड होगा। अगर वो डॉक्यूमेंटेड हुआ तो देन 91 लग जाएगा। बट इफ द कॉन्ट्रैक्ट, ग्रांट और डिस्पोजिशन इज रिक्वायर्ड टू बी गेट रजिस्टर्ड एंड इफ इट वाज नॉट रजिस्टर्ड, रिक्वायर्ड टू बी रजिस्टर्ड है बट रजिस्टर्ड नहीं हुआ, देन विल यू अलाउ द ओरल एविडेंस? then the oral evidence will not be allowed by the virtue of 91 part 2. अब एक और important point issue 49, you see 49, section 49 of the Registration Act, particularly clause C, no document required by section 17 or by any provision of the TPA to be registered shall affect any movable property. So it is basically talking about the effect of non-registration. No document required by section 17 or by any provisions of TPA to be registered shall affect any movable property comprised therein or confer any power to adopt. मतलब रजिस्ट्रेशन जरूरी है तो आप अडॉप्शन का पावर बिना रजिस्ट्रेशन के नहीं दे सकते। उसी तरीके से जिस प्रॉपर्टी के लिए रजिस्ट्रेशन जरूरी था ट्रांजैक्शन, अगर रजिस्ट्रेशन नहीं किया है तो विद रेस्पेक्ट टू दैट इमूवेबल प्रॉपर्टी नो राइट्स एंड लायबिलिटीज विल बी क्रिएटेड। फॉर एग्जाम्पल, आई मेक ए गिफ्ट of house to someone and I not get registered, then he will not become the owner, I will still continue to be the owner. Means no right will be created if the document is not registered. And the most important thing we are concerned here for right now is this clause. So no document required by section 17 etc. B to be registered shall be received as evidence of any transaction affecting such property or conferring such power unless it has been registered. अब इसमें ये कह रहे हैं कि अगर किसी डॉक्यूमेंट को रजिस्टर करवाना जरूरी था और आपने उस डॉक्यूमेंट को रजिस्टर नहीं करवाया है तो वो डॉक्यूमेंट उस ट्रांजैक्शन को प्रूव करने के लिए एविडेंस में अलाउड नहीं है। If any transaction which is required to be registered and if you documented that transaction but you have not registered that document, and since that transaction to be get registered required to be get registered but you did not registered it. Now if you tomorrow want to prove that transaction and for that you want to prove that document is unregistered and therefore that document is unregistered and therefore that document will not be allowed to be proved in the evidence. अब मान लीजिए मैं कोई मकान खरीदता हूँ, अब मैं कोई मकान खरीदता हूँ तो उसका सेल डीड तैयार हुआ होगा because it is a movable property and it is worth in more than 100 rupees and therefore उस सेल डीड में सारे सेल के टर्म्स लिखे हुए होंगे। अब section 17 clause 2 says, clause B says that I need to the document of sale deed get registered and here I not get it registered. I am the purchaser and B is seller and I not get it registered whereas I required it to be get registered. I am only having a document but not get registered. अब tomorrow if he has taken house from the me and I take the ground that I am the owner because I am a purchaser on filing the suit. Tomorrow if I take this ground in the court and in the court if I want to seek to prove the sale deed through the unregistered document, then will that sale deed be allowed to be proved? The answer is no as per 49 clause C. और दूसरा क्लाउज ए क्या कहता है कि इस प्रॉपर्टी पे किसी का राइट क्रिएट नहीं होगा, मतलब अभी भी वही व्यक्ति उसका ओनर होगा क्योंकि रजिस्टर्ड नहीं हुआ है। हालांकि अगर किसी ने फ्रॉड किया मेरे साथ तो फ्रॉड वगैरह के केस में वो केस कर सकता है। द लॉ विल नॉट अलाउ द फ्रॉड टू प्रिवेल बट हियर वी आर टॉकिंग अबाउट द नॉर्मल सर्कमस्टेंसेस the court will not allow me to prove the document. अब देखिए, मेरे और उस व्यक्ति के बीच there was a contract of sale of the house. He was the seller and I am the purchaser. So there was a contract between me and him, but that contract required to be get registered, and therefore the matter will not fall in part 1. It will fall under part 2 of the 91, and therefore the only documentary evidence will be allowed. So as per section 91 part 2 of that transaction between me and him, the documentary evidence will be permissible. So जो documents मेरे पास हैं वो मैं प्रूव कर सकता हूँ. अब लेकिन प्रॉब्लम ये है कि रजिस्ट्रेशन एक्ट एक स्पेशल एक्ट है, तो रजिस्ट्रेशन एक्ट लगेगा. 91 के अनुसार आई कैन प्रूव द नॉन रजिस्टर्ड डॉक्यूमेंट ऑल्सो. As per 91, I can prove the non-registered document also, because 91 simply says the document only has to be produced. 91 is not concerned about the registration or non-registration. But section 49C of the Registration Act is a special provision and 91 is a general provision. And a special provision always prevail. And here the special provision says what? That if the document has not registered, then that document cannot be proved in evidence. So ultimately what happened? Any matter which is required to be registered, if you not documented it, तब तो documentary evidence का मतलब ही नहीं बनता. If you have documented it, then as per 91 the documentary evidence will be allowed. But as per section 49C, if the document is not registered, that document, that unregistered document, will not be allowed. So 49C will prevail upon 91 in such a case. So write down all the matters which fall under the second part of section 91. The Registration Act also may apply. That is, certain transactions as per section 17 of the Registration Act are required to be registered. And in such cases, if the transaction is documented but not registered, then as per section 91 Evidence Act, the oral evidence will not be allowed, but the document will be allowed to be proved. However, section 49C of the Registration Act is a special provision in this regard, and therefore the Registration Act section 49C will prevail upon the section 91 of Indian Evidence Act. As per section 49C of the Indian Registration Act, such document which was not registered cannot be used in evidence, and therefore, despite section 91 of Evidence Act, Indian Evidence Act, even the documentary evidence will not be allowed to be proved. So that's it for this topic, section 91. Now there is certain small points to be discussed. अब suppose मान लो कोई contract, grant or disposition which is not required to be get registered and which the documentation is also not done, and since it is not necessary to be get documented, so oral evidence is allowed to prove that, then it can be done by virtue of section 60 also. अब एक point है, will would take effect from the moment the person died. एक व्यक्ति है, उसने will कर दी किसी भी अपने बेटे के नाम, दो बेटे हैं मान लो, दो बेटे और एक विडो को छोड़कर गया कोई व्यक्ति, उसने अपने छोटे बेटे के नाम पर विल कर दी या फिर अपनी वाइफ के नाम पर विल कर दी. विल बड़े बेटे के पास है, उसने छुपा कर रख ली विल. व्यक्ति मर गया, द मोमेंट द पर्सन डाइड विल एग्जीक्यूट ऑन दैट टाइम. अब एग्जीक्यूशन इन जो प्रैक्टिकली देखते हैं, दैट एग्जीक्यूशन इज डिफरेंट थिंग. तो जब व्यक्ति मरा क्योंकि प्रॉपर्टी शुड नॉट बी रेस्टलिनियस, जब टी पे पढ़ेंगे इसमें डिटेल में बताएंगे। अब व्यक्ति मरा, अब विल उसकी डिक्लेयर नहीं करी, बेटे ने छुपा कर रख दी, तो सक्सेशन के थ्रू 3 पार्ट्स में चली जाएगी प्रॉपर्टी। बट इट इज अननेसेसरी whether that it is not necessary that it would come to the knowledge to other that will is there or not। जैसे ही कोई व्यक्ति मरता है तो विल उसकी एग्जीक्यूट हो जाती है, ऑटोमेटिकली वो लागू हो जाती है। अब जिस दिन वो विल बाहर आएगी, सबको पता पड़ेगी, द ऑटोमेटिकली ऑन दैट डे द प्रॉपर्टी विच इज गिवन टू द एल्डर सन और जो छोटा वाला बेटा, उनसे प्रॉपर्टी वापस लेकर उस विडो को चली जाएगी सारी। वाई? बिकॉज द विल इज ऑन द नेम ऑफ वाइफ, और उसके खिलाफ क्रिमिनल केस हो जाएगा बड़े बेटे के पास, क्योंकि उसने विल को छुपा कर रखा, 420 हो जाएगी। सो विल वुड टेक इन इफेक्ट द मोमेंट person died automatically. There is no need of special execution. So that's it for this lecture. Thank you for watching for this lecture.